Good morning. I'm Gary DeWaal, and this is Bridging the Week from March 26th to 30th, and today is April 2nd, 2018. Two broker-dealers' purported failure to act on red flags, both involving customer trading, resulted in separate Securities and Exchange Commission enforcement actions against the firms. In connection with one action, two former anti-money laundering compliance officers were also sued for their roles in their firm's alleged failure, as was the firm's chief executive officer. Unrelatedly, the SEC asked for public comment on NYSE Arca Inc.'s proposed rule change to list and trade shares of exchange-traded funds based on Bitcoin futures contracts. This week is one of spring recess for many families, but I will be stuck in my office catching up on piles of work. So I can at least try to leave a bit early every evening. Let's get started. Aegis Capital Corporation, a Securities and Exchange Commission registered broker-dealer, agreed to resolve separate charges brought by the Commission and the Financial Industry Regulatory Authority that, from at least January 2012 through April 2014, it failed to file suspicious activity reports with the Financial Crimes Enforcement Network of the United States Department of Treasury as required in connection with transactions that appeared potentially to involve market manipulation of low-priced securities. The firm settled its SEC matter by agreeing to pay a fine of $750,000 US and committing to certain undertakings, including instituting recommendations made by a compliance consultant. Aegis settled its parallel charges by FINRA by agreeing to pay a fine of $550,000 US. Contemporaneously, Robert Eade, Aegis' ultimate 100% owner and chief executive officer, and Kevin McKenna, the firm's anti-money laundering compliance officer from June 2012 through June 2013, also agreed to resolve SEC charges related to Aegis' SEC enforcement action. Mr. Eade agreed to pay a fine of $40,000 US, while Mr. McKenna consented to pay a penalty of $20,000 US, and not serve as a compliance officer or an AML compliance officer of a broker-dealer or similar organization for at least 18 months. Separately, the SEC filed an administrative complaint against Eugene Teresiano, Aegis' AMLCO, a compliance officer from September 2013 through approximately September 2015, who did not settle. According to the SEC and FINRA, during the relevant time, Aegis failed to file SARs on hundreds of transactions it should have suspected constituted fraudulent activity or had no legitimate business purpose. These transactions involved the purchases and sales of low-price securities by few customers that evidenced quote-unquote red flags of market manipulation, including high volumes during periods of low business activity. Among other things, the SEC said that the failure of the AML compliance officers to double-check why the firm's daily review process did not identify potentially problematic transactions, as well as their failure to file suspicious activity reports or create written analyses indicating that they even considered to file suspicious activity reports after red flags of suspicious conduct were expressly brought to their attention, evidence their willing aiding and abetting of Aegis' violations. Mr. Eade was charged with causing the violations directly. Wedbush Securities Inc., a broker-dealer, and Timothy Delore, a registered representative with the firm since 1981, were named in separate administrative proceedings initiated by the SEC for their role in an alleged pump-and-dump scheme aimed at retail investors from 2008 to 2014. Simultaneously, Ms. Delorme settled her SEC action by agreeing to pay a fine of $50,000 US and never associating with a broker-dealer, among other sanctions. According to the SEC, Ms. Delorme benefited from investing her customers in microcap securities that were subject to a pump-and-dump scheme by Isaac Zirk Engelbrecht, a.k.a. Zirk de Maison, who last year was sentenced to 12 years imprisonment for his role in the fraud that resulted in a $30 million US loss to customers. The SEC also previously brought charges against Mr. Ungebrecht and others related to the alleged manipulative scheme. According to the SEC, in late 2012 and early 2013, Ms. Delorme's supervisors became aware of numerous red flags regarding her conduct, including by reviewing email that purportedly outlined her role in fraudulent transactions involving penny stocks, receiving copies of 2 customer arbitrations with the Financial Industry Regulatory Authority filed by her customers that made, quote, serious allegations, end of quote, regarding her role in the same penny stock issuers, and becoming aware of FINRA's investigations regarding her personal trading of one of the relevant penny stocks, as well as the allegations underlying the customer arbitrations. However, said the SEC, despite being aware of these red flags, Ms. Delorme's supervisors continue to permit her to make investment recommendations to her customers. And finally, the Securities and Exchange Commission announced that it would formally consider whether to approve or disapprove rule changes to authorize NYSE Arca Inc. to list and trade shares of exchange-traded funds based on Bitcoin futures contracts traded on either the Cboe Futures Exchange or the Chicago Mercantile Exchange. The SEC solicited comments specifically regarding whether the relevant funds would have sufficient information to assess the fair value of the relevant Bitcoin futures contracts, what might be the potential impact of manipulation in the underlying Bitcoin markets on the fund's net asset value, how the fund's valuation policies might be impacted by Bitcoin forks, and what might be the impact of the high margin requirements for Bitcoin futures contracts on the liquidity of such markets and the ability of funds to meet redemption orders, among other topics. In January, the SEC's Division of Investment Management issued a letter to 2 industry organizations stating its belief that, as of now, it was not appropriate for investment fund sponsors to seek registration of SEC-regulated funds, such as mutual funds or exchange-traded funds, to, quote-unquote, invest substantially in cryptocurrency and related products. This was because, quote, there are a number of significant protection issues that need to be examined before sponsors begin offering these funds to retail investors, end of quote, said the division. At the time, the division implied that until questions were answered, quote-unquote, satisfactorily, it was not likely to consider for approval any registered fund to invest in cryptocurrencies. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.